Hello everybody and welcome to this webinar on legal privilege for in-house lawyers. My name is Emma Chown and I'm an editor in the Practical Law Dispute Resolution team at Thomson Reuters. I'm delighted to have with me here today Colin Passmore. Colin has been the senior partner at Simmons & Simmons since 2011, where he also continues to maintain his litigation practice. In addition, Colin is the author of one of the leading textbooks on legal professional privilege, known by many of us as Passmore on Privilege. It's in its third edition, and I understand that Colin's working on the next edition, which I think you're hoping to finish sometime in the next few months?
Yes, in the next few months, but yeah, don't tell my publishers that the date is fluid.
Right. So after a brief refresher of the basic elements of legal professional privilege, we're going to discuss some of the case law and developments affecting the law of privilege and some of the issues which may arise for in-house lawyers in particular. Now, just before we start, I need to let you know about a couple of housekeeping points. First, if you experience technical difficulties with this WebEx session, please message the WebEx producer using the Q&A panel. Second, as a reminder, this event is being recorded for rebroadcast. Finally, we encourage you to submit written questions at any time during the presentation using the Q&A panel located at the bottom right-hand side of your screen. After typing your questions in the space at the bottom, hit the send button, and please make sure you direct your questions to all panelists in the Ask menu. Time permitting, we'll try to address some or all of your questions towards the end of the session. So, without further ado, let's get on. Colin, if you don't mind, I'd like to start by going back to absolute basics and reminding listeners of exactly what legal professional privilege is.
Legal professional privilege is a right that is unique to the clients of lawyers, and it is a unique right in the sense that it entitles those clients to withhold from scrutiny any of their communications with their lawyers that relate either to the seeking or obtaining of legal advice, and we'll come on to some of the detail in a moment, or in relation to the process of litigation or other forms of contentious investigations. This right is unique because it is only available to the clients of lawyers. It contrasts with the rights, for example, of the clients of accountants and other professionals. Those communications will be confidential, but they are always capable of being compelled. So whereas our discussions as lawyers with our clients and our communications, so we're talking about written and oral communications, cannot be compelled without the client's consent, those of other professionals can. And this means that in litigation or in regulatory investigations, for example, nobody can force the client to hand over details of these communications or to be questioned about them. It also means that because Parliament recognises the importance and power of privilege, it always legislates, save in a couple of very small but important respects, on the basis that investigatory powers, whether on behalf of the police, the revenue regulators, insofar as they can compel people to come in for questioning or to give up documents and so forth, they cannot encroach upon privilege. The justification for this was developed a couple of hundred years ago, and it is to assist the administration of justice to ensure that clients, recognizing this secrecy, are willing to talk to their lawyers as openly and frankly as possible. And the theory goes that thereby the administration of justice will be aided because if lawyers are in full possession of the facts, they can advise, for example, to do A instead of B. They can advise whether or not to take a case to trial, knowing that being able to tell the client whether they will win or lose. We'll come on in a moment to look at the two types of privilege. We're talking about legal advice privilege and litigation privilege. Both of these are fundamental common law rights. They are protected by Articles 6 and 8 of the Convention, and they are, as I said, very, very powerful rights and privilege as a matter of English law. I'm just talking about English law is inviolable.
Thank you, Colin, for a very full answer. So as you said, we're going to focus on legal advice privilege and litigation privilege today. So could you briefly describe the requirements for each of them and also explain any particular implications for in-house lawyers?
Yes, certainly. I think the starting point is that when I'm referring to lawyers, as a matter of English law, I'm covering both external and internal lawyers, although there are some wrinkles where in-house lawyers are concerned, where you, the listeners, are concerned, and there are, of course, some European law issues, which I will touch on briefly. But otherwise, I and you are in exactly the same position for what I'm about to describe. The most frequent of the privilege, or the most frequently used of the privileges, is legal advice privilege. This protects communications between us as lawyers and our clients. So for most of you, or in fact all of you, that will be your business clients within your business organization that employs you. For me, it will be any of you if you were to come to me for advice. So what is protected is communications between lawyers and their clients that are concerned with the seeking or giving of legal advice. It doesn't matter what the topic is. It can be anything, the interpretation of a statute, the interpretation of a contract, of a statutory instrument. It can be advice on how to draft a contract. It can be advice on how to set up corporate structures. It can be advice on tax law, anything where there is what we call a legal context. Subject to the in-house lawyer wrinkle, which I will come on to in a moment, I would suggest that 99.9% of what I and you do on a daily basis will be concerned with legal advice that is protected by this first head of privilege. The second head is the one that is concerned with the litigation process. This is what we call litigation privilege, and this protects communications between either the lawyer or the client and a third party, where those communications are made for the dominant purpose of litigation, and that litigation is pending or reasonably in contemplation or actually afoot. And the main difference between the two privileges is that here we are entitled to communicate with third parties, such as factual witnesses or expert witnesses, and there must be a connection with litigation. So the communication must be for what is called the dominant purpose of that litigation. With legal advice privilege, the legal advice sought can cover any subject. It doesn't have to be in connection with litigation. And there is just a question mark as to whether that, under legal advice privilege, there is a dominant purpose. I personally don't think there is. And the most important thing to ask is, are we in a relevant legal context? Are we being asked to give legal advice? Now, the position with in-house lawyers has this wrinkle. Some of you, and I think this probably applies to those who become more senior within the organisation, perhaps up to GC level, certainly sometimes where some of you might sit on a board, you have to be sure that you are giving legal advice. If you stray into the business context, unless there is still a legal context, if you are giving just pure business advice, for example, you may be asked about your business's strategy, unless you can point to a legal connection, it is arguable that you're not giving privileged advice. So that's just something to watch out for. I suggest, however, that for the majority of the time, what you're doing in your capacity as an employed lawyer is giving protected legal advice. Do remember, however, that once we get into a European Union context, particularly competition inquiries, the European Court of Justice does not recognise in-house lawyer privilege. So if you are the subject of a European Union investigation, not a domestic one, if you're the subject of a European Union investigation, the European Court will not recognise privilege in anything, not just competition issues, but anything where the advice has been sought from or given by you as an in-house lawyer.
Thank you, Colin. And you mentioned that legal advice privilege applies to communication passing between a client and their lawyer. We've already had several questions which were sent in advance by some of our listeners about the definition of lawyer, including one which asked about whether an in-house legal executive would count as a lawyer for the purposes of privilege.
Right. The starting point is that everyone who is qualified as an English solicitor will have to have a practicing certificate. Those are the rules of the SRA. And so for the vast majority of us, we can recognise who is a lawyer for the purposes of privilege. But the Supreme Court recognised a few years ago that privileged advice can also be given by legal executives, if you're a member of what is called SILEX, I think. But even within the in-house community, within the legal community, even within an external law firm, we and you will employ lots of lawyers who are qualified in non-English jurisdictions, overseas jurisdictions. They don't necessarily have a dual qualification. We all, I think, probably have trainee solicitors and paralegals. All of these individuals, if they're working under the supervision as lawyers, if they're working under the supervision of a qualified lawyer, they will be able to give privileged legal advice.
Thank you, Colin. And I mentioned it's communications between the client and the lawyer, so that leads to another knotty question. Who is the client? One would have thought the answer should be straightforward, and indeed it is very straightforward where the client is an individual, but it's not as clear-cut where the client is a corporate body. And so that's in part because of the now infamous Court of Appeal decision in Three Rivers No. 5, where the Court of Appeal gave a very restricted definition of client and held that it would only cover communications between the lawyers and a small group of the bank's employees who were actually charged with instructing those lawyers. So unfortunately, that case leaves us with some uncertainty about who the client is. For example, in a large corporation, is it the legal department or the corporation as a whole or somebody else within the corporation? Now, I don't think there's been any case law clarifying this point in this jurisdiction, although there was an interesting Hong Kong case on it in 2015, which you might like to just mention briefly. But I just wondered, what's your approach to this issue, Colin, when advising clients, and what would you suggest that in-house lawyers do in relation to the question of who the client is?
Right, well, let's just first of all be completely clear about what the problem is. When we are talking about legal advice privilege, and we do not have litigation looming, we all, by which I mean external and in-house lawyers, must be clear who our client is. It is not, Emma, as you've just said, anybody within the organisation which employs you as the in-house lawyer. You do have to look at this narrower group of people who, according to Three Rivers No. 5, are the small group of people who have been charged with seeking your legal advice. Now, there is some debate as to whether that is the correct interpretation of Three Rivers No. 5. I think that is the safest interpretation. And I take a little bit of comfort in the fact that Lord Neuberger, the President of the Supreme Court, who gave a speech last month, in fact in March, also reflected that that is the proper, the more likely interpretation. And he dropped a little bit of a hint that the Supreme Court would really like to revisit this, and who knows what result we would get. But the problem is that, as he said, and as the authorities say, Three Rivers No. 5 is the guiding authority at the moment. And so unless we have litigation in prospect, when these issues just simply fall away, when, for example, you start, let's say, a regulatory investigation, let's say it's a non-contentious investigation at this point, you have to give really deep thought as to who your client is. And therefore, who are the individuals within your organisation with whom you can communicate with the benefit of privilege. And unfortunately, in that situation, the reality is that there are many communications that need to be made in order to gather information or to seek the answers to questions in that sort of context that simply won't be covered by the privilege according to Three Rivers No. 5. My approach is always to say at the outset of this sort of matter is for me and the in-house lawyers advising me to sit down and work out who is the Three Rivers No. 5 client, i.e. who is that smaller group within your organisation who have been asked to coordinate the investigation and to get the advice. Now, it could be that little group, if we try to determine who it is at the outset, we might find that we're attacked on this if there's litigation 5-10 years later. It hasn't happened so far, but my view is that in most cases, and every case is going to be fact-specific, that is the safest way to go. And that's certainly, I think, what Lord Neuberger seemed to indicate in his speech a few weeks ago. Now, the problem with this case is, as I say, if you start, for example, with a non-contentious investigation, it can become contentious. Litigation privilege will kick in at that point, and these problems fall away. Personally, I think the Three Rivers No. 5 decision is a really bad one, and it is notable that Singapore, Hong Kong, and Australia have all said that they won't follow it. This does give rise to the conundrum that you could have an investigation that goes on as between England and Hong Kong. You could undertake communications in Hong Kong that are perfectly privileged under English law, but if the real scene of the legal action is the London court, those same privileged documents in Hong Kong could become unprivileged in London. So it is a real problem. And one can only hope that at some point the Supreme Court gets the chance to sort this out properly. But it is a real problem.
Thanks. That's a very practical answer, Colin. And so we've been talking about giving or receiving legal advice, but I think at least in part because of that restrictive interpretation of the meaning of client, which was given in Three Rivers No. 5, there's sometimes concern about disseminating legal advice within an organisation. What advice would you give to a corporate client or in-house lawyer in that regard?
Right. Well, I think the first point to emphasise is that Three Rivers No. 5 is concerned with who we can communicate with the benefit of privilege for the purposes of giving the legal advice that has been requested. Three Rivers No. 5 has no application to the position of what you do with that advice once you are in a position to give it. And that means that, for example, if you have your Three Rivers No. 5 small client, you give them that advice, they may then need to give it to a wider body of people within your organisation, perhaps the board of directors, perhaps a supervisory committee, perhaps a remuneration committee. It really doesn't matter. Dissemination of confidential and privileged advice within an organisation does not give rise to waiver. I always advise as a practical matter, don't disseminate it beyond those who truly need to see it or know it, because the more people who have it, the more chances that it will get left on a bus or a train and so forth, or the more risk that people will inadvertently send it to people who shouldn't have it. But dissemination of legal advice within an organisation is perfectly okay, and it has to happen in order to enable your employers to use your advice and to take decisions based upon it. Otherwise, there's simply no purpose taking your legal advice. And this position has been recognised in a whole series of first instance cases, and there just isn't a problem with doing this. And that means that, for example, if there's a debate about the legal advice at the board level, obviously you've got to think about how you minute that and who else has a look at this legal advice and comments on it. But the dissemination of itself is absolutely fine.
Thank you, Colin. I think, that's interesting that you emphasise so strongly that dissemination isn't a problem. I mean, does that apply where you're disseminating to employees as opposed to perhaps more senior people? And for example, we've had one question sent in advance asking about whether sending emails which might contain privileged information to internal sales clients would be a problem.
Let's take a practical example. Supposing someone has said to you, can we have advice on the new consumer rights legislation? Can we have advice on distance sales regulations? Can we have advice on the sale of goods legislation? Or let's have advice on a to the salespeople who need to know what this new legal development is so that they don't go and missell. So giving your advice to those who need to see it and to use it and to abide by it is perfectly okay. Otherwise, these people could never have legal advice. So nobody is going to, well, I was saying nobody. Desperate litigants who are well armed will attack anything if it will delay things or if they think it will raise an argument that they might just win. Otherwise, no one is going to attack you for sharing your information within an organization outside of the board of directors, e.g. to the salespeople who really need to know what this advice is. Now, you probably don't give them a QC's opinion or your own opinion. You will probably distill your advice down into bite-sized and digestible chunks. And those chunks, to the extent that they cover legal advice, will still be privileged. And you've got to be able to give them to the very people who need to abide by your advice and guidance.
Okay, that makes good sense. I mean, but that said, do you think it's a good practice to qualify when you pass on the information to qualify it with confidentiality obligations, so to label it as privilege and to make it clear that it doesn't constitute a waiver when you're passing it on and so on?
Yes, I do, for several reasons. I think a lot of non-lawyers don't understand privilege. A lot of lawyers don't understand privilege, but a lot of non-lawyers don't understand privilege, and so they need to be educated in the importance of preserving the confidentiality so that it isn't subsequently lost. That's the first thing. So the second thing that arises from that is you should mark this sort of communication, whether on the face of a memo and the covering email, as privileged and confidential. The only danger here is if your colleagues, your non-lawyer colleagues, see this and they themselves start using the privilege tag in completely the wrong circumstances. It does sometimes get a bit out of control. But I think it is good practice for lawyers to mark their advice as privileged and confidential, and so as to emphasize to the recipients, when they're not lawyers, that they're dealing with something rather special, because that is what privilege is. It's a very special, it's this unique right, and it needs to be looked after.
Okay, thank you. And you also mentioned giving legal advice at board meetings or disseminating it at board meetings, and that's absolutely not a problem. And obviously that makes perfect sense. Otherwise, you couldn't actually make use of it. Yeah. But what about if there's then a sort of discussion about the advice? If that discussion leads to discussing what's going to be done as a result of the advice, and all of that's minuted, are the minutes privileged at that point?
The discussion of the legal advice and what to do with it will be privileged. The recording of the discussion in the minutes, insofar as those minutes reflect, refer to, quote, or allude to the legal advice, will be privileged. It is good practice, I think, in such situations to perhaps have either two sets of minutes or certainly two sections in the minutes that clearly distinguish the privileged advice from the unprivileged advice, so that if there is an attack at a later stage, you've got the basis of your defense or your argument that the discussion was privileged, and that therefore the discussion shouldn't be the subject of any inquiry or any disclosure by an opponent in litigation or by a regulator. And I think also if for example, if the board doesn't actually meet, if emails start flying around to say, what is this advice? Can you just clarify what does Section 2 mean? What about Section 4? What if? I think all of those sort of emails, trying to understand what the advice is, what it's trying to say, they will all be privileged. Although there is a small danger there if people start introducing new information, new facts that will then require the advice to be qualified, you're potentially back to your Three Rivers problem. So you do have to try to cut down the email traffic, because there is always a danger of just undermining the privilege in this situation. But broadly speaking, the vast majority of cases, discussion at board or committee level of privileged advice is going to be absolutely fine.
Okay, thank you, Colin. So moving beyond sharing legal advice within the immediate company, What about a situation where a subsidiary company wants to share legal advice it's received with its parent company, or the other way around? Can it do this without losing privilege in that advice?
Yes, indeed. Yes, indeed, under English law. The sharing of privileged advice under English law between two separate legal entities, whether they be human or corporate entities, so long as that's done under conditions of confidentiality, is perfectly permissible. And indeed, within a multi-company organisation, this happens a lot. And I don't think I've seen many instances of this being queried. The one thing that perhaps everyone needs to watch out for is that because I'm only talking about English law, I'm only talking about what the position is if there is a dispute in England or if there is regulatory attention in England. You have to, in these situations, just give some thought as to what is the position in other jurisdictions. So, for example, although I don't have huge amounts of knowledge about this, my partners in Germany and Italy tell me that, for example, there are certain regulators in those countries, certainly the criminal justice authorities, in respect of whom privileged documents in the hands of in-house lawyers in those jurisdictions can be compellable. And so I know that in some cases in Germany we have adopted a practice with our clients whereby we will hold the privileged advice and the in-house lawyers will come and read it in our offices. They do not want a physical or soft copy because in their hands not everything can be completely sacrosanct from the local authorities. So there are some countries where we really do have to watch out for this sort of problem. Subject to that, if you're sharing between, say, any of the common law countries, England, Channel Islands, Ireland, Australia, Hong Kong, New Zealand, Canada, this sort of sharing isn't really a problem. But it's always as well, I'm afraid, to get some quick local law advice before you do the sharing.
Yeah. So I think, Colin, you addressed the next question there as well about the subsidiary sharing legal advice with its parent company or any other company within the group in a different jurisdiction, which is very helpful. And now that we're talking about jurisdictional issues, what's the situation where legal advice is provided to a company by a foreign in-house lawyer? I think you touched on this earlier, and I think it probably comes down in part to what the definition of a lawyer is.
Yeah. In the Prudential case in the Supreme Court about 3 years ago, when tax accountants tried to persuade the Supreme Court that they should have the benefit of legal advice privilege, one of the issues that troubled the judges was this. They held that privilege has only ever been available for lawyers who they defined as solicitors, barristers, and legal executives. But they were faced with the anomaly that English law recognizes privilege over advice given by a French or a German or an Australian or an American lawyer, whether they are giving advice respectively on French, German, Australian or American law advice, or indeed whether any of them stray into giving advice on English law. So there is this anomaly under English law, but the English courts, I think, for reasons of comity and also because this would cause so many problems, the Supreme Court held that foreign lawyers giving legal advice, that advice will be privileged under English law. Now, whether it is in other jurisdictions, I'm afraid, is always a matter that has to be checked locally.
Thank you, Colin. And in fact, we've had another question that was sent in advance, which sort of turns that whole situation on its head and asks, what about a UK qualified in-house counsel working in a jurisdiction elsewhere? And I assume that's really down to the law of that jurisdiction. Yeah,
I'm afraid it is. If you are practicing in Hong Kong, for example, or New Zealand, almost certainly the English qualified lawyer's advice in those jurisdictions, so long as you are employed as a lawyer in-house or externally, your advice will be recognized as privileged locally. What happens once you're in France and Germany and the Netherlands, I'm afraid you really do have to go and check, and I don't know the answer.
That's fair enough. Okay, so moving on. I
can find out the answer.
some recent developments in privilege. There were several decisions in 2015 about what constitutes legal advice, including in the case of Property Alliance Group and RBS, the citations on the slide. Yeah. Could you tell us a bit more about that decision and what you think the implications of it are?
Yeah. I find it fascinating that about every 5 years a piece of litigation comes along that just produces privilege decision after decision after decision, and this case is no different. And indeed, as we're sitting here today, an aspect of this case is in front of the Court of Appeal right at the moment, but not this particular decision. This is a really, really good and sensible decision for lawyers, in-house or external, because the essence of this decision, without going into the facts, it's an alleged libel, mis-selling or misrepresentation case. This was a case in which RBS was facing regulatory investigations in quite a few jurisdictions, and their solicitors, Clifford Chance, produced to something called an executive steering group, which was monitoring the investigation. So this ESG was in effect the Three Rivers No. 5 small client. They were getting reports from Clifford Chance on a weekly basis that were updating what was going on in these regulatory investigations from time to time around the world. And initially, the judge who first heard this, Mr. Justice Burse, wasn't satisfied that the evidence that the bank put in front of the court had made out a case for privilege over these reports. And a little lesson here is that the other side brilliantly exploited some fairly small inconsistencies in the way in which the claim to privilege had been described as between correspondence, as between statements, and as between skeleton arguments. So the first lesson coming out of this case is you have to have consistency in the way you describe things. And we all know how opponents can exploit in litigation the smallest inconsistency. Anyway, because the judge wasn't satisfied that privilege was properly claimed, he said there should be another hearing in front of Mr. Justice Snowden, who should look at the documents concerned and decide whether or not there was, in fact, a claim to privilege. And what he looked at were these confidential memoranda in the form of tables prepared by the solicitors, as well as confidential notes and summaries concerning discussions between this executive steering committee and the legal advisors when this committee met with the lawyers every week or so. And these tables informed and updated the steering group on the progress of the investigations, their status, the issues arising. So they weren't always giving pure legal advice. What they were doing was just monitoring what was going on around the world. And the judge said that he was entirely satisfied that these documents were privileged. There was a relevant legal context, that's the regulatory investigation. This was part of that continuum of communication where something is ongoing, so you're asked to give legal advice, and as part of giving that advice, every so often you report some factual developments. You don't necessarily give advice on this, every single one of those factual developments. So there's this constant process of updating, keeping the committee informed. And this just shows that if you have an internal investigation, if you structure it properly at the outset, if you give some thought as to who your client is, and if you do as the solicitors did here, properly mark everything private, confidential, privileged, you're flagging that you think this is legal advice. That becomes very helpful when you get challenged over this. But it also shows that this whole process of looking after a big problem, investigating it, updating, occasionally giving some real legal advice on particular issues, that all comes wrapped up in this process of communicating, and that will be privileged and therefore not disclosable to the opponent in litigation. So it's a really, really good case.
Very useful case.
Very useful.
Yeah, okay. Now, I'm conscious that we've only got about 10 minutes left, so I'm actually going to jump over the next question because I want to get to a couple of the questions that have been asked by people who are listening. So we're just going to do a couple more of our tech questions, and then we'll move on to a couple of the questions that have been asked. So last year, there was another case, Sharp and others, and Blank and others, which raised some interesting issues about joint privilege privilege and when it can arise between a company's shareholders and the company itself. Could you tell us more about the findings in that case?
Right. I think it's often not appreciated that when a company gets into litigation with its shareholders, subject to an important exception, the legal advice that the company has, if it's relevant to the dispute with the shareholders, is actually disclosable to them as part of that litigation. So the shareholders don't have a right to that legal advice outside of litigation, but once they're in dispute, they are entitled to see that advice, and the company can't say it's privileged as against the shareholders. So this decision was a fantastic reminder. And the circumstances of this case were pretty extraordinary. It all concerns Lloyds Bank's takeover of HBOS back in 2008, when the then Chancellor Gordon Brown effectively made Lloyds buy HBOS. At the time, there were some shareholders who weren't particularly happy about this, and in due course, many years later, their proceedings started to go through the High Court. I don't know if they're still running. They may have been struck out, but I'm not sure about that. And Lloyds, I think, were understandably, my reading of the case, by the way, I have no inside knowledge, my reading of the case, they were understandably alarmed that all the advice they took from QCs and Linklaters and others back in 2008 was potentially disclosable as not being privileged as against the shareholders. And as a result, they sought to invoke the exception, which is the same as trustee and beneficiaries in this situation. If the company takes legal advice about the dispute with the shareholders, then in that situation you can assert the privilege. And Lloyds tried to argue that because a number of shareholders had voiced dissent or unhappiness with the purchase of HBOS back in September 2008, therefore you have the foundations of the subsequent litigation, and therefore the advice was privileged. And I think the Judge Nugee, Mr. Justice Nugee, was only asked to rule as a matter of principle, but he held no. In that situation, it didn't seem to him that the exception came into play. So a very good reminder that shareholders can get access to a company's privileged material subject to a litigation exception.
Thank you, Colin. That's very helpful and a practical reminder. Now, I do have one more question which I was going to ask, but again, I'm going to jump over that and just come on to a few questions that have been asked by people listening. And the first one's actually one that was sent in advance, which is, in what circumstances, if any, can regulators override a privilege claim?
Regulators have no power to override a privilege claim. All of their compulsory powers to summon people to interview or to give them documents have a privilege exception provision in them. And that's the FCA, the SFO, the police, HMRC, you name it. Now, of course, it has become the practice of some of these regulators to make it clear, subtly or less so, that a determination to assert privilege is not something that is going to be seen as cooperation. We know that the SFO has made lots of public noises about this. And so therefore, companies have, I think, been put under a certain amount of pressure to waive privilege. But if a company wishes to assert privilege and the crime fraud exception does not apply, the regulator can do absolutely nothing about this. So you have to check the statutory power, and there are virtually no statutory powers that override privilege. There is one that I would just like everyone to be aware of, and it does slightly go back to the point Emma's just jumped over. The government's new proposed investigatory powers bill is proposing to give to the security services an express power to eavesdrop on privileged communications in any circumstances where this is thought to be in the interests of national security. And I think this is an incredibly unfortunate development, and we will pay a heavy price for this over the years. But anyway, I will rant about that in other arenas, not today.
Thank you, Colin. I know you gave evidence on behalf of the Law Society to the Joint Select Committee on that bill, and I think concerns have been expressed following that by others as well. So let's hope that your concerns will be recognised and something will be done about them. Okay, so another question that's come in, and I know this is one that we get asked through our Ask service at Practical Law. So I think it's worth asking here, can privilege over company documents be asserted in a claim against one of its directors?
Right. There is a case from 1991 called Darby & Co. against Weldon, number 10. In other words, there were 10 interlocutory decisions where the judge said it does not follow that a company can rely on the privilege attaching to instructions and advice passing between the company and its solicitors, copies of which have been supplied to the company director, if there is subsequently litigation between the company and the director where the advice or instructions are material to an issue raised in the litigation. So I think that means that if the legal advice is relevant to the dispute with the director or the director certainly, then and if the director has seen it, then the privilege can't be asserted.
Okay, thank you, Colin. I'm going to ask one more quick question. Okay? Yeah. Can litigation privilege be claimed when the issue underlying threatened court proceedings is investigated by a non-lawyer in a company's legal department?
Right. The truthful answer is that litigation privilege can be claimed by communications made by a non-lawyer where they are made for the dominant purpose of the contentious litigation or the contentious investigation. The realistic answer is not to broadcast this within your organisation, because you then get non-lawyers going off doing these things without fully understanding what privilege is. And they may or may not get it right. You may or may not have a good claim to privilege. So the truthful answer is non-lawyers can engage in litigation, communications protected by litigation privilege where they are within the dominant purpose and all the rest of it, but it's not a terribly advisable thing to let your non-legal colleagues do, I would suggest.
Okay, thank you very much. It only remains for me to thank Colin for participating in this webinar and for providing such comprehensive answers, and thank all of you for listening and for sending in questions. You can obtain additional information on privilege on the Practical Law website, including an overview practice note on privilege and a flowchart on privilege, which was designed especially for in-house lawyers. And you can access Colin's book through our website.
Or buy it.
Well, I was going to say, if you subscribe to Westall, or you can buy a hard copy of it, exactly. Now, there were a few questions which we haven't been able to get to, and we'll try to address those individually after today's session. So thank you and goodbye.
Thank you.